Counselors, you know we get letters, emails, and phone calls from people with legal questions. And this first question goes out to you. What can a person do if they're the beneficiary of an estate, but they don't trust the person who's in charge of the estate?
Well, the consequences that you're probably not aware of are loss of privacy primarily, in that the publication of your affairs in newspapers and in other public media. Therefore, I'd like to answer that with a story with regard to a client that decided that after conferring with me, decided not to proceed with any formal estate plan and basically went home, wrote on a piece of paper, I give everything to my 3 children equally. A will, it met the California requirements of a holographic or handwritten will. And as we proceeded with the probate process, numerous creditors claiming on the estate by virtue of a plumbing bill and that stucco bill that the executor of the will had no knowledge of. And as a consequence, we got bogged down with a loss of time, a loss of privacy, and a loss of monies, because the expenses of probate were somewhere in the neighborhood of $22,000 for this particular estate, where a simple estate plan would be merely a fraction of that. So in the case of trying to do it yourself, you certainly can do so, but the cost of doing so will be passed on in a negative way to your beneficiaries. And it gives your children or your heirs the insight that in order to pass property once one dies, one should plan as if one plans for a vacation or plans for building a house. And such planning is reflected in your estate plan, and such planning is as much a benefit to the heir as the gift itself.